Good afternoon, everyone. It's good to be with you again. We've got another full program for you. We're going to try and, I think, today give you some perspective on a few things. We've had a chance, I think, this week to take a breath, at least in part. So we're going to start off today with Hermes Fernandez. Hermes, as everyone probably knows, is a member in our Albany office. And he's going to start us off with some comments on the Department of Health Emergency Rule. Take it away, Hermes.
Thanks, Pete. Yes, I've spoken many times. I'm getting used to speaking to the air and feeling less like a crazy person doing it. So I apologize. I don't have any PowerPoint for you today. I couldn't prepare the PowerPoint because I was really spending time trying to nail down some of these issues and chase them down. There was some ambiguity in some of the regulations that have come out, and I think we've got some answers for you. So as Pete mentioned, I'm going to start by talking about the Department of Health's emergency regulation. The department issued a regulation on Friday dealing with COVID-19 and under the department's authority to address contagious diseases. The department has classified COVID-19 as a contagious disease. It's been classified since March when the department first put out an emergency regulation. The regulation that was put out on Friday is actually an amendment of that emergency regulation, but it was extensively rewritten. Now, as a legal matter, what the emergency regulation does is it serves as a legal underpinning to many of the emergency orders that the governor has put out and to the guidance that has come out from the Empire State Development Corporation. But the regulation itself is fairly bare bones. It nevertheless does several significant things. It should be kept in context, and you'll remember this from earlier webinars or from other things that you've read, is ever since the governor began the New York shutdown way back in March, which seems like forever ago now, we've been operating under what's been called the New York pause. From New York pause, as the state has begun to reopen, we've moved into New York forward. But it is New York forward while still on pause. As confusing as that sounds, the regulation helps to clarify some of that. We still live today under the stay-at-home orders of New York pause. The workforce reduction rules are still in effect, except as they have been lifted under New York pause. The prohibitions on gatherings are still in effect, except as they have been lifted under New York forward. And I think I said New York pause a moment ago, New York forward under all of these things. And the restrictions on gatherings are in place under New York pause, except as they have been lifted under New York forward. So where does that leave us? We have the rules we've talked to you about previously are in effect. Offices can reopen. Right? Many businesses can reopen. Malls can reopen, all with various restrictions. Office space, for example, the workforce can go up to 50% of occupancy. That's all confirmed by the regulation. What we see, though, is a couple of emphasis points in the new regulation. And the first is masks. As a lawyer and as a presenter in these programs, I'm glad that the regulation is actually ratifying what we've told you in other programs. Masks are required, must be worn just about everywhere. If you're in public, the thought should be you must wear a mask. If you're in your office or if you're in your workplace, you must wear a mask unless you're in a circumstance where the mask interferes with your work, or a mask is otherwise something that's not conducive to your health. And that's actually intended to be a high standard. That is not intended to be, geez, I just don't like wearing a mask. I'm uncomfortable with a mask. Masks are to be worn, right? And this goes for all public places, whenever you cannot socially distance, including transportation. You take an Uber or Lyft, or even, God forbid, something as ancient as a taxi, you have to wear a mask. Right? That's a requirement. And there's a requirement that the drivers wear masks. You get on the bus, you wear a mask. You get on the subway, you've got to wear a mask, right? You don't wear a mask when you're in your own car by yourself with your family. If you're with others, actually, non-family members, you're supposed to be wearing a mask at that point as well, because you were not socially distancing at that point. The regulation goes further and pushes hard on the requirement to wear masks, because the regulation makes explicit what we have read into the guidance documents as implicit. Businesses and building operators, right, and their agents, those who run the businesses or run the buildings, must enforce the mask requirement, right? This is in line with no shirt, no shoes, no shirt, no service. Now it's no shoes, no shirt, no mask, no entrance. I know there are some who believe there is some liberty interest that they have that says they don't have to wear a mask. That simply doesn't hold water. You're required to wear a mask just as you are required to wear clothing in public. You are required to wear a mask. The exceptions are for children under the age of 2, and for individuals where they needed an accommodation under the Americans with Disabilities Act. So that is not a broad set of exceptions. There's penalties, explicit penalties now for businesses that fail to do this. Businesses and building operators can be subjected to a $2,000 penalty. Individuals can be subjected to a $1,000 penalty. So this mask requirement, whether masks work or don't work, we'll leave that to others. The rule is you must wear a mask. I also want to mention a couple other points regarding other orders that have come out since Friday. There is also a travel advisory, which we've talked to you about previously, which had a number of states. The governor has added teeth to this, to the travel advisory in the last couple of days. Yesterday, the governor announced that all New York airports that take interstate flights, so which is pretty much every public airport, will include tables that will be staffed by New York State troopers and peace officers. With travelers coming off of planes will be required to have completed a form. The form is online, it's available electronically, and the governor's people are working with airlines to have these forms distributed on planes, where if you are coming from one of the affected states, you must identify where you've come from, and you must identify where you are going in New York, and you will be told that you must provide contact information as well as your location. And while there's a penalty already in place for failure to abide by the 14-day quarantine that is required if you have come from one of the covered states, the penalty will now also apply if you refuse to complete the form. So there's some real teeth in the travel advisory now. 4 more states were added today: Minnesota, New Mexico, Ohio, Wisconsin, including that goes with the other 18 states. So more than half the country is now covered by this travel advisory. The governor's people put some real teeth into it. And I'm going to talk again later at the end of this program. I'm going to flip back to this and what this shows, or what this may show us going forward. Pete, I can conclude with that.
Great, Hermes, thank you. We're going to turn now to Adam, and Adam is going to try to summarize, where we are in terms of reopening and pull together some of the themes. Maybe before we jump into that, Adam, we've had 3 or 4 questions here about face shields as a form of face covering. You want to handle that one before you jump in to your affirmative presentation?
Sure, Pete, thank you. Yeah, so I saw a number of questions in the chat asking about whether face shields were an acceptable face covering. The answer to that is yes. In general, they are. There may be certain jobs that require more protective PPE, but for example, in the office setting, the New York State guidance specifically says that face shields are one of the acceptable types of face coverings. So that's pretty clear. I also saw, Pete, some other questions in here about if you can maintain 6 feet of social distance, whether you are required to wear a mask. According to the guidance, and again, I'm answering this specifically related to office settings because I think that's where these questions are coming from. If you are in your office, if you have a private office and you're able to maintain 6 feet of social distance, you don't have to wear a mask. However, if you are in any of the common areas of the office space, such as the hallways or the bathrooms, etc., the guidance is clear that you have to wear a mask regardless of whether you can maintain the 6 feet of social distance. So if you are in your office, you don't, and no one is around you, you can maintain the 6 feet of social distance. You don't need to wear the mask. But when you are in common areas, the guidance is very clear that you do need to wear a mask. Pete, do you want to add anything to that?
No, I mean, I think that's probably a reasonable summary of where we've been throughout, right?
Yep.
Social distancing or a mask.
Correct.
And I think the idea with the common areas is that you don't know when someone may happen upon you, and all of a sudden your ability to social distance will be impaired. So that's the
Exactly.
rationale, I think, behind all of this.
Exactly. Okay, so I wanted to first touch on some of the frequently asked questions that we are still getting with respect to reopening. Upstate New York, Central New York, and other parts of New York first entered phase 1 on May 15th. So we've had more than a month and a half, almost 2 months now, of reopening guidance to digest and plans to draft and put into place. We have a good handle on where we are with respect to the reopening. But I wanted to touch on some of the questions that we're still getting, and hopefully they are useful to those attending the webinar today. So first of all, we're still getting questions about what to do with employees who don't want to come back to work or don't want to work in the office. And I guess, or the advice we've been providing is that each case is its own individual analysis, but there is a decision matrix or a decision tree that you can walk through as an employer. So first of all, you need to understand the reason why the employee is hesitant or reluctant to come back to work. If the employee doesn't want to come back to work because of general fear, because they want to stay on unemployment, that's one thing. But if they don't want to come back to work because if they have a legitimate underlying medical condition, or they're a high-risk individual, it's a different analysis. So the first question that you have to ask as an employer is, why do you not want to come back to work? Once you have the answer to that question, I think the next step has to be whether the individual is entitled to some protected leave under the 2 or the 3 really leave laws that the federal government and the state government put into place. The federal government has the emergency paid sick leave, and it also has expanded FMLA. And then the state has its own version of the emergency paid sick leave. So you have to ask, does the reason that the employee is giving fit within one of the categories that would entitle them to leave under any of these emergency COVID statutes? If the answer to that is no, then you move on to the next layer of questions, and that is this leave going to be protected under any other statute, such as the Americans with Disabilities Act or Family Medical Leave Act? So you're going to ask the questions of the employee that would give you the information necessary to make that determination. The next layer is if the employee's leave would not be covered under the COVID statutes, it would not be covered under any other statutes, you have to consider whether you have an existing collective bargaining agreement or some other contractual requirement that would impact your decision about whether or not an employee is entitled to leave. So some of the common reasons that we heard early on, I haven't seen them as much anymore, but reasons that employees were giving were that they were generally afraid of coming back to work. So that particular reason would not be protected and would not entitle an employee to protected leave under any of the statutes that I mentioned, unless the fear or the employee received some medical documentation or medical reason that being at work would exacerbate a pre-existing anxiety condition or other mental health condition. So general fear typically is not a protected reason for staying out of work. Similarly, if somebody says, I'm making more on unemployment then I would be working. That's also not a protected reason. Now that reason is going to become much less significance at the end of the month when the federal government's $600 bumper for unemployment benefits expires, unless the federal government extends that. As of right now, it's our understanding it has not been extended, so we'll keep an eye on that for you. Another common reason that employees have been coming up with is that they have a loved one at home who is high risk, who fits into one of the high risk categories. Again, this doesn't necessarily entitle someone to a protected leave, but it is a consideration, or it's something that you as an employer should take into consideration when you're deciding how to deal with that employee. So as you walk through this analysis, there are really three different potential outcomes. First of all, the employee could be entitled to some form of protected leave, whether paid or unpaid, under the statutes that I mentioned. So you would put the employee out on leave, and then they'd come back, they'd have a protected right to come back. Another potential outcome is that the employee is not entitled to any protected leave, so you may have to discipline the employee up through and including termination. Given the circumstances surrounding COVID-19, everybody is obviously trying to be as considerate as you possibly can. So terminating people for these reasons is an extreme step and should be done so carefully. But it may be a step that you need to take. So again, this is an individual analysis based on an individual employee, and circumstances may warrant termination. Another potential outcome is that you provide an employee who's not entitled to any leave with an unpaid leave. So you could say, look, I understand your concerns. I understand what you're going through. We're going to allow you to go on an unpaid leave and then come back. But again, it's an individual determination. Now, we've also had clients that have asked us what to do if they have an employee who is a high-risk employee who they are concerned about bringing back to the office or bringing back to the facility. Typically, the answer will be that you cannot prevent someone from coming back to work just because they are in a high-risk category, unless their disability poses a direct threat to their health that cannot be eliminated or reduced by the use of a reasonable accommodation. So this direct threat analysis is what you're going to have to go through, and it's a pretty high burden to keep someone out from the employer's point of view. In addition to questions about employees coming back to work, we've also received a lot of questions, and we are still receiving a lot of questions about employer liability. Businesses are rightfully concerned about what their exposure might be in the event of somebody who contracts the virus while on their premises. So that question, or what your liability is going to be, will depend on a number of factors. So first of all, who are you concerned about liability from? I think you have to look at this in two different categories. One is your employee, and then the other category is everybody else: visitors, customers, vendors, etc. With respect to employees, generally, an employee, if an employee could prove that they contracted COVID-19 at work, which would be very difficult to do, but if they could do that, workers' compensation will typically be the exclusive remedy, and an employee would not be able to bring a lawsuit against an employer based on a theory of negligence. So for employees, you're generally going to be covered by workers' comp, even if they can prove that they contracted the virus at work. With respect to the other category, visitors, customers, etc., there are a number of defenses that would be available to employers. First of all, my position has been all along, and it still is, that your best defense will be that you had a plan in place that complied with state and federal guidelines. You implemented the plan, you communicated the plan, and you followed through with the plan. That's going to be your best defense. It will be very difficult for a plaintiff to show that you were negligent as a business if you had a plan in place that complied with guidelines and that you followed the plan. So that's really going to be your biggest and best defense. Another defense that you'll have is is a causation type defense. It's going to be very difficult for plaintiffs to prove where they contracted the virus, particularly plaintiffs who aren't working at a business for 8 hours a day, but who were, let's say they were a customer and they were in a Home Depot for 10 minutes. It's going to be very difficult for them to say that they contracted the virus while they were there. So causation defense will be available for businesses as well. Businesses may also have the defense of the assumption of risks. So in other words, people who come into their facilities or offices assumed the known risk of contracting COVID-19. At this point, it's everybody knows about the risk of COVID-19 and how it spreads. Employers and businesses can take additional steps to enhance their rights with this assumption of risk defense by either posting signs at their offices or businesses, or having visitors sign a statement that they are acknowledging the risks that are present. Either one of those options would enhance the assumption of risk defense. So that's available to businesses as well. Finally, businesses have the option of using liability waivers. This is, again, going to be a very individualized determination. Liability waivers are limited in their enforceability and in application in many ways, both statutory and practical. So you're really going to have to sit down and think about whether a liability waiver makes sense. And I think it's important to distinguish between a liability waiver, a waiver that someone would sign that says, I'm not going to hold this business liable even for their own negligence. That's one thing. That's a liability waiver. An assumption of risk, which says, I understand that there are potential risks of me catching this disease, and I'm acknowledging and assuming those risks. So those are two different things, both available if appropriate. So that's really the employer liability question. That's an overview of the analysis that we've been using for employer liability questions. The last topic that I wanted to go over were briefly. Yeah.
Real quick before you move on,
Yep.
We're getting a lot of questions here that involve very fact-specific situations, and I think that's the nature of everyone's inquiry. That everyone is going to say, "Great, now that we understand the general rules, we have the specific questions." So, I think those are things that our advice would be twofold, that you have to work through them on a case-by-case basis. That's always been the rule with respect to disability accommodations and some of those issues that you spoke about. But I think it's also the rule here, because we're getting questions like, if employees can work at home, what about returning to work? And then we're getting questions like, if we've got, a cubicle, is that an office? And all of these things are very fact-specific. And so I guess I'm going to encourage everybody to look at your facts and then probably work with your attorneys to work through it. I don't think we can give you a one-size-fits-all answer to these sorts of questions. They're very interesting questions, but it's going to be the kind of thing that you just have to work through based on your business and the guidance and, frankly, the continuing updates that we get, because this has been evolving from the perspective of, the governor's office and the Department of Health as we go.
Yeah, Pete, that's great advice. In these webinars, we are pretty limited. We can give you a general overview of what the issues are and what the rules are. But as many of my colleagues can tell you, the past 2 months has been filled with fielding very fact-specific questions. And this is unfortunately not the appropriate forum for answering those fact-specific questions, because the facts will determine what the advice is. So please, if you have questions, reach out to me, reach out to Pete, reach out to Rick or Hermes, any attorney that you typically deal with, and we'll be able to help you. Pete, I wanted to just go over very briefly the travel question. I know that we've done a lot on this in the past couple of weeks. I don't want to be too repetitive, but I think it's worthwhile to summarize where we are with the travel quarantine restrictions. So I think that the baseline is this. if you or anyone who lives in New York State travels to a hotspot state and comes back, or travels to a hotspot state for more than 24 hours, I should say, and comes back to New York, you're going to be required to quarantine for 14 days. I think that's the baseline. You start from there, and then you go through the analysis from that point. So many of our employer clients have been asking two big questions. The first one is, I have an employee that traveled to a hotspot state and they came back. Do I have to pay them? So again, if you think about this as a decisional matrix, you start with the question is the employee essential or not? So let's say the answer to that question is no, the employee is not essential. So then you move to, can the employee work from home? And if the answer to that is yes, then you allow the employee to work from home during the 14-day quarantine period and you pay them as you regularly would. If the answer to that question is no, they can't work from home, well, then generally the employee would not be entitled to paid leave under New York State's Emergency Paid Sick Leave Act. The governor issued an executive order making that clear. But if the employee traveled for work reasons, then they would be entitled to that leave. In addition, the employee may be entitled to leave under the federal Emergency Paid Sick Leave law because the governor's statement that that personal travel isn't covered by the state law has no impact on the federal law or its application. You also have to look at whether or not a collective bargaining agreement or other employment contract will govern your rights as an employer to grant or deny vacation requests. And if there are any other clauses in one of those type of agreements that would impact your ability as an employer to sit somebody out. You're going to want to look at those contracts to determine whether or not you have authority to approve vacation. And if you do, what are your rights? So that's the analysis on how you pay or whether to pay someone who goes on vacation, is a non-essential employee, and comes back and has to sit out for 2 weeks. The other question we've been getting quite a bit is what to do with essential employees. And unfortunately, the way that the state guidance is written, the answer to this isn't crystal clear. The state put out some FAQs on the travel advisory that unfortunately didn't clear up too much. But the way that we're interpreting this for the most part is that if there are a couple of different categories of essential employees that are contemplated by the guidance. One, healthcare workers. So if your essential worker is a healthcare worker, there is specific limitations on allowing them to return to work after they've traveled to one of these locations. If you are an essential employee who is symptomatic or has been exposed to a confirmed positive case, there are another set of limitations or restrictions that would allow that person to work. And then if you're an essential worker in any other category, then the guidance appears to say that you have to follow the long-term guidance, the guidance for essential employees who are traveling to New York State for a long-term period. So that's a general overview of the travel restriction issues. There are quite a few more questions I know. I know we've covered this ad nauseum. We've also produced several client alerts and memos on our blog about it, so please feel free to consult those as well. But that's it for me, Pete, on the general reopening update.
Thanks, Adam. A lot of information in there. And again, feel free to reach out if you have specific questions. We're going to turn now to Rick Weber. Rick is a member in our litigation group here in Syracuse. And Rick's going to give us an update. We've talked about this, I think, a little bit over time, but now with the benefit of a little bit more time, we may have a little bit more perspective. Business interruption insurance claims in the age of COVID-19. Rick, take it away.
Thanks, Pete. Good afternoon, everyone. Next slide, please. As Pete indicated, I am a litigator, so I approach this as a litigator would, trying to figure out what the arguments might be that each side would be raising. And so I reviewed some of the recent cases and some of the recent commentary on where these disputes are going. This first slide basically details exactly what you would need to know if you find yourself in a position where you have a potential business interruption insurance claim. And the first rule is always read your policy. Any claims in relation to insurance coverage are always going to be dictated by the specific terms and conditions of the policy. That's where you're going to find the specific definition of perils or hazards or losses that are covered. And that's where you're going to find the nature and amount of losses that would be covered under the policy. It's worth noting here as well in business interruption insurance claims that sometimes business interruption coverage is part of a multi-peril or global business owner's policy. So if you are considering whether you have business interruption insurance, if you've not looked at it yet and you don't have a separate policy that says business interruption, you may find those terms in a kind of combined global policy. Important terms to keep in mind as we discuss this is the term property damage. This is normally what a business interruption insurance policy is designed to address. It's some kind of damage to property that prohibits your business from being able to operate. And the most common example is a fire claim. In your primary office location, if you suffer a fire that prevents your business from being able to conduct normal operations, that's kind of the prototypical business interruption claim. The other thing to bear in mind is that business income is related, but it's not identical in any way to property damage. Business income loss is what happens when you cannot operate your business. It is not the business damage in and of itself. Next slide, please. So if we look at some notable trends, a lot of these are not going to be terribly surprising to you. Insurers are making arguments that governmental restrictions such as stay-at-home mandates do not constitute the physical damage or physical loss that's required to have a cognizable claim against the policy. In other words, your business premises may be absolutely fine, absolutely intact, and you may in fact have individuals who can access that business location. And yet the only reason they're not doing so is because of a local or statewide stay-home mandate or other restriction on access. So that's a common argument that's being made by insurers across the country. Similarly, arguments that actual physical damage from COVID-19 is not a real extensive damage or loss. This contamination is fleeting. We're dealing with a virus that could be promptly remediated by disinfectants, in theory by a thorough cleaning, quote unquote, right? And so these are losses that could be avoided or limited. Insurers are also raising arguments about policy exclusions. This is not a surprise to anybody who does work in the insurance coverage area. Your policy covers specific identified losses. And invariably in your policy, there will be certain exclusions to these losses. And we are finding a lot of litigation now over the scope and nature of losses that in particular, clauses that in particular bar losses that are directly related to concerns over virus exposure or disease exposure, the kind of prototypical pandemic things that we believe we're experiencing around the country. And then there's the basic arguments that you always have by insurers on late notice of claim, right? That insurers, had they received an earlier notice of claim, could have acted more promptly to address the loss. Next slide, please. On the other side of the aisle, we're having arguments by claimants. Just waiting for this next slide to get up. But the claimants are making arguments, as you might expect, that they are suffering some losses. And one of the key arguments that are being addressed by claimants are that the concept of physical damage is not the same as the concept of physical loss. That policies that are defining the terms as a physical impairment or actual alteration of the structure due to the hazard or the peril cannot possibly be the same as a loss of access, what we would call physical loss to the property. And there are policies that speak about damage and loss, and where that occurs in particular, that's a notable distinguishing feature, these claimants will argue that because they specify damage and loss must be separate things and not the same. And that's currently being litigated throughout the country. Also, one of the things that's worth mentioning is that there's arguments that these exclusions must be narrow if they're adopted at all. And there's some arguments that exclusions for policies should be read very narrowly. And so that's what a lot of the claimants are arguing. Next slide. There we go. Yes, this is my list of things. One of the interesting arguments that's coming out of here is the concept of, again, what exactly a stay-at-home mandate might mean in the context of a business interruption insurance claim. And here I'm making reference to something that's related. It's called the Civil Authorities Clause. Civil Authorities Clause is a clause that pops up in a number of policies. You would have to, of course, check your own policy to see if it's there. And the civil authority concept is that where a governmental entity, for a reason of an emergency or an important governmental objective, prohibits access to your business premises, the business interruption coverage should be triggered. In other words, it does not, it kind of supersedes this question about whether there's a direct physical damage to the property, and provides coverage for when civil authorities act to deny the business owner or operator access to the property. So we're seeing some of those questions pop up in the cases about these civil authority clauses as well. And then there's arguments that we're finding about bad faith denial claims. Some individuals, some businesses rather, are making claims under business interruption claims, and some carriers are promptly rejecting those claims under arguments of either an express exclusion or simply that it doesn't fall within the scope of coverage. And some of the claimants who have their claims denied are beginning to push back on that and say that a kind of prompt disclaimer is not appropriate, that what really needs to occur is a thorough investigation. They need to appreciate the loss, the sensitivity. You can imagine this may be particularly relevant in scenarios where the business is inviting members of the general public in, and now, because of governmental mandates, it's very difficult to allow members of the general public into the business premises. Next slide, please. I promised I would keep this generally short here. This is arguments by insurers. Let's go to the next slide. I had done that previously. Yes, things to watch. Last one first. A lot of how these claims are going to go down are going to depend on decisions and determinations by courts regarding the scope of policy exclusions and the nature of those exclusions. Exclusions, as a general rule, are read fairly narrowly and are read in favor of the insureds, just as a general matter of contract interpretation. And so there are a number of claims right now in various state and federal courts that are trying to have courts make determinations about the scope of policy exclusions, specifically virus exclusions and disease exclusions. Another thing that's worth watching and is going to weigh on many of these claims in the coming weeks are legislative initiatives. And most recently, New York State itself has a couple of bills. There's an Assembly bill and a Senate bill that essentially is going to try to mandate business interruption coverage within a certain scope of prerequisites, right? It's going to be it's going to have to relate to any policy that was on force on or after March 7th. It's going to relate to any businesses that had 250 or fewer employees. It's going to work out definition of what an employee is, part-time versus full-time. And if those prerequisites are matched, the insurance companies will then have to provide the business interruption coverage to essentially wipe away any exclusions. As you might imagine, there are a lot of concerns about that, not only from insurance companies, but just generally on how you might manage these things. And one of the issues that's coming up is the concept of developing a fund that if the state is going to really move forward with a plan to mandate this business interruption coverage, then perhaps there should be a funding mechanism. And the pending bills in the Senate and in the Assembly are setting out kind of a basic funding mechanism idea, but frankly, those are not close to law yet. It's also worth mentioning there are legislative initiatives being started in the U.S. Congress. Representative Maloney, downstate, in fact, has submitted a bill to try and create a fund similar to what was set up to cover insurance losses in relation to 9/11. Again, it remains to be seen exactly where that's going to go, especially given that the U.S. Congress has been focused more directly on other kind of economic recovery and infusion packages that they've been passing here since March. So that's really all I have to report on this at the moment. Drop a quick case. There was a case involving Berkshire Hathaway and one of its subsidiaries that actually was just argued yesterday in Pennsylvania. We're waiting on a decision to see what happens on there. That was one involving business interruption, involving a firmly defined and set forth exclusion in relation to viruses. The claimant there was a restaurant owner who was making the assertion that because of Pennsylvania law regarding shutdowns, they should nevertheless now be able to avail themselves of this business interruption coverage despite an exclusion. That case and many other cases dealing with similar fact patterns are obviously going to become relevant in the coming weeks. But at this point, I again have to go back to that first slide that I put up there. The most important factor in any business interruption claim is going to be the specific terms and condition of the policy that claim is made under. Everything's going to flow from that. So we'll keep watching and provide further update here as we move forward in further weeks, but that's where we stand today. Pete?
Thanks, Rick. Very comprehensive. A lot to keep our eye on here. I think we're going to go back to Hermes to provide us a little bit of perspective. Hermes always has a dual role of looking at where we are, but also trying to look ahead for us. So, Hermes, why don't you give us a few thoughts here?
Yeah, thanks, Pete. So where we are, where we're going here. I do want to mention one answer to some of the questions that folks were popping up, and this may be in terms of where we're going. Folks have been asking questions about what happens if a state that borders New York, such as Pennsylvania, goes on the travel advisory. My expectation is that the travel advisory rules will be rewritten, but that may not be the case. As the travel advisory is currently written, those individuals would not be able to come back into New York because they'd be required to quarantine while they're in New York. And that you'd have that same 14-day issue. You'd have the same issues that Adam mentioned regarding essential workers. So there could be exceptions for essential workers. But the way the travel advisory is still written, there is not an exemption for individuals living in contiguous states. Going further in terms of what to expect, let's use a short-term horizon of September. The governor has been very explicit. He's been very transparent, actually, through this entire crisis, talking about what he's looking at and where he may be going. And he is clearly very concerned about what is happening in other states. Florida, North Carolina, South Carolina, states that New York has traveled to create great concern because of the concern that individuals in those states will be bringing back the COVID-19 virus, right? That hence the travel advisory. But when you look at Ohio and California, those are states that are really cautionary tales for New York, because Ohio and California are two states that were regarded as having taken quick, stringent, effective measures to reduce the spread of the virus. Ohio has been added now to the list of states, which means it is restricted states, which means it is now getting positives in over 10% of cases, as is California. The governor said on Friday he is concerned that no matter what we do, there will be another outbreak in New York. Certainly, leading epidemiologists are saying similar things, right? We are now finding ourselves being surrounded by rising levels of infection. So, on that gloomy note, where are we going? Let's talk about some things that are more specific, such as school reopenings. At this point, if you were to look at the numbers that New York is reporting, schools should be reopening in September. Now, under what form they'll reopen, we don't know, but the governor said yesterday that schools will reopen if the infection rate in New York State is below 5% on a rolling average, a 14-day rolling average. Schools will close once opened if an infection rate on a 7-day rolling average, so a shorter period of time, exceeds 9%. The governor said the decision to reopen schools will be made the first week of August. He actually didn't say first week, he said between August 1st and August 7th. As schools reopening is a leading domino, right? That's a leading indicator, because if schools reopen, it's much easier for the workforce to come back to work. At this point, every region in the state is reporting numbers well below 5%. There have been some surges in cases, some of which have been actually traced to out-of-state travelers. The Albany area where I live, so the capital region, actually has the highest percentage as of yesterday at 2%, and that was due to an outbreak, some of which was traced to travelers coming back from Georgia. There have been outbreaks in central New York. We talked about those a week or two ago. There was a food processing plant in central New York that had some numbers. In western New York, there have been some increases, but the increases so far have been identified. The folks have been isolated. The contact tracing has been being done and used, but we are seeing issues there in terms of what may occur. Some of the other things we're seeing that are actually have happened in the last week, and hopefully these will continue to happen, is there have been new rules announced to allow nursing homes and assisted living facilities to have visitation, which is a long time coming. Group homes, community residences, known by various titles, that are operated under license from the State Office for People with Developmental Disabilities. They have now been allowed to have visitation, and actually allowing their residents to go to visit their families and then come back to their residences. That's very significant. That's a positive sign. But as we watch these things, it is all really about where are these numbers going, what else we may see. One other thing that I've seen in some of my reading as we're going forward, there's been quite a lot of discussion about vaccines, whether vaccines will be available. There's been discussion about whether vaccines will be effective, how effective, and when they will become available. Some of the early indicators suggest that some of the vaccines that may come to market, if they could come to market next year, might have effective rates of about 50%, while researchers continue to seek more effective vaccines. But one of the bright spots seems to be, apart from the question of vaccines, is there has been increasing improvements in the means of transmitting individuals with COVID-19. And that appears to be continuing. There have been some drugs that have been identified, remdesivir most prominently, but other issues have come up as well, simply in terms of the use of oxygen and the positioning of patients in holding back on using ventilators and identification of people with COVID-19. There also at this point seems to be some change in the individuals who are being identified as positive. Much, much higher levels of positive tests among people who are younger. And that is why the death rate has gone to a much lower rate. Because when you go through the numbers, 95% of those who have been suffered a fatal case of COVID-19 have been over 50. 98% of those who have suffered a fatal case of COVID-19 have been over 40. So the cohort of individuals under 40, while they are at risk, have been much less at risk. And that may lead to something different in the fall, where we may see that instead of widespread closures, we will get to an issue that Adam was talking about, which is, do we begin to identify high-risk groups? Do we take people over 60 like me and say, you know what, we don't want you to come into the office. We are telling you, you are obese, you have high blood pressure, you're over a certain age, you have underlying conditions. Are we going to actually start to deal with placing restrictions on those folks and allowing people who are at lesser risk to move about more freely? That is going to be an incredibly difficult issue. It has been talked about, for the most part, rather flippantly, but I think we're going to start to see much more discussion about that because the costs of closing are so difficult. So with that thought, with that possible debate, Pete, I'll come to a close.
Thanks, Hermes. I will say you're sending chills down the spine of a labor lawyer when you start down that road. But it's a reasonable policy discussion to anticipate. So, all right. With that, thank you, everyone. Good to have you with us again this afternoon. Thanks for spending a few minutes with us. Everybody, please stay safe. Have a good week, and we'll talk to you next week.